Presenters alone. They do not represent the views or opinions of Valley News Live, our parent company, or our advertisers.
With us right now live via Skype, UND constitutional law professor Aaron Lay. Aaron, thanks so much for taking some time to join us today after this obviously historic decision by the SCOTUS about the Defense of Marriage Act. I guess my first question to you is this, and one of the things I think I want to preface this with, Aaron, is I'm not a legal guy. I'm not a law guy. I don't like all this legal jargon. So if you can talk to myself and our audience tonight like we're on, are you smarter than a fifth grader kind of thing, that would be, at least for me, fantastic. Our audience is very smart. I have my own issues. But here's the thing. Why did the SCOTUS come out today? Obviously, Clinton signed this thing into law in '96. Why did the SCOTUS come out today and say, hey, this is unconstitutional?
Well, first of all, thanks for having me on, Chris. And it's been a real interesting day for us constitutional law professors. And it's been an exciting week of speculation for a lot of these cases. And as you were saying, Bill Clinton did sign the Defense of Marriage Act into law in 1996. And it kind of wound up to the Supreme Court in a number of steps. The structure of the act, there's two sections of the act. The first section pretty much says that if there's a marriage that's recognized in one state, it doesn't have to be recognized in the other. And the other part of the act defines marriage as a federal, from the federal government standpoint. So when they're looking at whether to give benefits to people and things like that, or whether to possibly, if you might have two gay soldiers who eventually might get married and they want to get buried together at a veteran cemetery right next to each other, then the federal government wouldn't allow that to happen under DOMA. And so it was those types of issues that caused this case to be heard before the Supreme Court.
But here's my ultimate question for you. So shouldn't we have known back in 1996 it was unconstitutional to do this if, in fact, the Supreme Court made the right decision today? So why today does it all of a sudden become, oh, wait a second, this thing apparently is unconstitutional? It's not like the Constitution's changed recently.
Yeah, that's a good question, Chris. And right off the top of my mind, I could probably give you a pretty good answer for that. There wasn't a lot of states that recognized gay marriages back in 1996. And so when they were putting together DOMA, they didn't have a lot of that to worry about at that time. The other part of the answer to that question is that as these cases are in the federal district courts and moving around or percolating in the federal court system, that can take a number of years for those cases to reach the U.S. Supreme Court.
But I guess here's my thing again, and maybe I'm belaboring the wrong point, but it seems to me that many people look at the Constitution, especially strict constitutionalists, and say, hey, this thing goes on forever. It's principle-based. I don't know if you heard my first segment, but that's what I was saying is, look, if you're principle-based and you're going to be a conservative and say, hey, I want the government closest to the people to govern this thing, where now all of a sudden, if this is principle-based, does it become unconstitutional? Because even if I look at the Bill of Rights, I don't see any specific information in the Constitution talking specifically about marriage, whether it's between a man and a woman or a man and a man.
Well, yeah, that's another good question, Chris. The Fifth Amendment, which they base this decision on, talks about liberty and equality and things like that. And so that's pretty much where a lot of the reasoning for this decision is coming from.
Let me ask you this, because I think a lot of people have asked this question. So let's say, as we know now, Minnesota, the 12th state in the union to legalize same-sex marriage. Let's say I live in Minnesota, I get married in Minnesota, but then I move to North Dakota. Are those federal benefits going to carry over to North Dakota, or once I move to a state that does not obviously recognize same-sex marriage, do those things now get, I guess, I no longer have those benefits?
Well, I wish I could give you an accurate answer to that. Right now, it would be pure speculation, but I imagine that, yes, like Social Security benefits, if somebody's been married in Minnesota and they move over to North Dakota, that they would have access to the benefits of that. The real interesting question arises when there are issues where state governments are running federal programs. That's where you might run into some real complications with this ruling that came down today.
But wait, I guess, so you're saying if I got married in Minnesota and then moved to North Dakota, I'm still going to get those federal benefits. But what I'm understanding from this decision is essentially the SCOTUS is going, look, let's just let the states deal with it. If it's legalized, then obviously, yeah, they can continue with those federal benefits. But I'm hearing you say, Hey, if I go from Minnesota now to North Dakota, those federal benefits are going to carry with me into a state that prohibits same-sex marriage?
Well, like I said, Chris, these are issues that are going to come up. It's going to be interesting to see how these issues play out. But what I'm most concerned about one of the things that I foresee is when, let's say that you get married in Minnesota and you're living in North Dakota and you're applying for food stamp benefits, which is something that's usually delivered by states and counties and things like that. There's going to be a lot of questions about how to deal with issues like that.
A lot of people on a particular side of the aisle, if you will, are going, okay, here we go. Now we've got this thing strucken down, so it opens up the door, obviously, for homosexual marriage. The next step is going to be now we're going to legalize polygamy. Legally, do you agree with that?
No, I really don't agree with that. The Supreme Court really came down on that a long time ago. There was a case that arose over there in Utah that dealt with polygamy, and polygamy is fundamentally different. You're dealing with multiple people getting married. With gay marriage, you're dealing with two individuals entering into contracts with one another, whereas polygamy it's fundamentally different than the situation that we're dealing with there.
Aaron, I want to keep you with us. I want to take some questions from our audience for you and let you share your thoughts on that as well. If you do have any specific questions, again, Aaron Lay with us, UND constitutional law professor. But hey, what does all this mean? Whether it's about Prop 8 or the stricken down of DOMA today via the SCOTUS, let us know. You can go to our website, 630pov.com. If we can bring that graphic up, please, and let people see the email address there, as well as the number there you're going to see at the bottom of your screen. You can text us there. We'll get those things right away and ask your questions to UND Professor Aaron Lay. Stay with us. We'll be right back. Welcome back. We're talking about the Supreme Court decision today about DOMA, the Defense of Marriage Act. Still with us via Skype, the UND constitutional law professor Aaron Lay. Aaron, thanks so much for sticking around. I want to get to some questions and things that have come in via Facebook, obviously during the show as well. Give you a chance to comment on those with more of your legal expertise. First thing that come in, what does the U.S. Supreme Court's ruling in the Prop 8 case mean for legalizing same-sex marriage in California?
Well, that's a good question. It's a very complicated case. It deals with a lot of procedural issues. And what the Supreme Court essentially said is that the parties that brought the case, there's a problem with the parties that were bringing the case. And so they said that they're not going to hear it. And when the Supreme Court makes a ruling like that, the decisions by the lower court stand. And so as it stands right now, gay marriage will be legal in California.
The thing I don't understand is Prop 8 was voted as yes by the people of California, saying, hey, we don't want this. But now the Supreme Court won't hear it. They're going to say, okay, we're going to continue with same-sex marriage. Help me understand that.
Yeah, one of the issues here was that the people that were bringing this case before the U.S. Supreme Court, it was a group of people that were bringing the case. And what the justices wanted was they wanted an individual who was harmed by this case. So when it first started out in the case, the people that were bringing it were the people that were denied marriage certificates. And so when they were denied marriage certificates, they were harmed by that. Now, the group that brought the case hasn't necessarily been harmed by that. And so that's the issue that's come up right now. Chief Justice John Roberts has pointed toward ways in which groups, an individual will be able to bring this case before the U.S. Supreme Court again.
All right, I want to get to another point of view that came in. Jamie Thiebaud, I believe it is, says times have changed, but I find it funny that Bill Clinton has come out praising the decision when he's the one that signed it into law back in 1996. Now, you and I kind of touched on this already, but just want to get your thoughts. And here's a president that we think obviously is very intelligent. He signs this thing into law, and now it's coming and going, boy, I'm so glad that the SCOTUS actually shot this thing down, even though I signed it.
Right. Yeah, and you have to look at the political context of the time, too. Back in 1996, you had Republicans who had taken over Congress in 1994 during the Republican Revolution. And it's my understanding that during that time, you had Bill Clinton that was looking for ways in which he could compromise with Republican majorities. And that was essentially it. And let's not forget that during his time in office, Bill Clinton was moderately conservative on some of these issues. And I'm not talking about abortion issues and things like that, but on some of these issues, he was moderately conservative. He was the governor from Arkansas.
So you don't think this is really a political play to help Hillary down the road, for him to come out and bang the drum and go, hey, this is great now. I'm so happy to see this happen. Oh, by the way, my wife's probably going to run in 2016.
Well, I certainly think it's going to be difficult for any Democrat to win a primary and be hostile toward gay rights and things like that. So it could possibly be the case. I don't have any inside information on that, but I can imagine that this is a community that you're going to want to reach out to in primaries and things like that.
Yeah, we know that it was costing President Obama a lot of money when he was sort of saying, hey, I'm evolving on this decision at this point. Another point of view that came in, Bill Clinton, today's decisions are a great step forward for marriage equality. This is his tweet, Ashley, grateful to all who fought tirelessly for this day. One more point of view that came in I want to get to and get Aaron's thoughts on it. To the sender of the idiot teabaggers remark, beware, that is borderline hate speech. I love this because, we always hear about the liberals that it's about tolerance, Aaron. We're all about tolerance. And then we see comments like that, idiot teabaggers. Just your comments on that real quick.
It's too bad that we do have to sometimes have conversations like that. It'd be nice to sit down and come to some sort of compromises and to cooperate with one another. And that's how they used to do it back in the day. And it seems like there's a lot of divisive issues out there today. And there's a lot of other explanations for that I'm not going to get into. And I'll just leave it at that.
All right. Another point of view that came in. Do you think that with the defeat of DOMA, it will open the door to more states allowing same-sex marriage? So do you see now same-sex marriage beginning to sweep across the U.S. and having more state legislators and people going, hey, maybe this thing is a good thing. Let's vote it into law in our states?
Well, one of the things that I think I want a lot of the viewers to take home with them today is that DOMA hasn't been struck down. There's only a part of DOMA that's been struck down, and that's Section 3 of DOMA. And so I don't know if this is going to lead to more gay marriages or not. The pattern in which we're going in the United States, it certainly seems that there will be more and more states adopting statutes that would allow the gay community to marry. But otherwise, I'm not sure if DOMA's going to have a huge impact on that or not.
All right, another point of view I want to get to. If SCOTUS truly based their rulings on the Constitution, why does their political party affiliation matter? Does case law trump the Constitution? Great question.
Yeah, that is a good question. And I'm not going to get into all the research about this. And your viewer is absolutely correct. Conservative justices tend to vote conservatively on a lot of issues. But your viewer also has a good point there, too. And that's that justices are somewhat constrained in the decisions that they make. Kennedy, he's a Reagan appointee, and he's still in the majority on this particular vote. And so sometimes they look at Congress or they open up the newspapers before they make decisions. And I imagine that not a lot of people are going to like that, but a lot of research says that there are those types of influences on judicial decision making.
Well, I want to get to the second part of his question as well, because it seems like we are beginning more and more as a nation to sort of almost relative law versus constitutional law, where people are not going back to, hey, this is what the Constitution says, this is what case X, Y, and Z said, so let's use that, obviously, as we go and battle this thing out. I think there's some truth to that. Do you find the same thing, or am I missing something?
Well, it's interesting that you say that, Chris, because I was thinking about this myself. And oftentimes you have precedent that is on both sides of the cases. And so it's easy for a justice to use one particular case to justify his or her vote, and for another justice to use other cases to justify his or her vote. And so that is something to think about. But another thing to keep in mind is that there are various provisions in the Constitution, and a lot of them conflict with one another. And you have the Bill of Rights versus the original Constitution, and you're always going to have conflicts. And to some extent,
so
that's how the framers wanted it.
What specifically is conflicting in the context of the Constitution?
Well, for instance, if you have an interstate commerce clause issue, and then you also might have an issue that deals with free speech or personal freedom or something like that might conflict with that. We saw that with the Affordable Care Act case. And so oftentimes you'll see this, but yeah, you're right. And I can see why conservatives might be a little upset with this, because Congress over the years has expanded their authority to reach into certain areas that they haven't in the past.
Aaron, we really appreciate you taking the time. Thank you very much. Look forward to having you back on in the future, okay?
It was great being on here, Chris.
All right, buddy. Take care. Appreciate it. We'll talk to you again soon. Stay with us when we come back. We're going to get to our final view and tell you what's coming up tomorrow night on the show. As always, be sure and join our conversation. Go to the website, 630pov.com. There you can email us, text us. Let us know what you feel. We'll be right back.